Hi, if you've been named an executor or personal representative of an estate that includes real property, there's a new Missouri law you need to know about before you sign anything. My name is Terry Peterson. I'm a real estate agent and investor in St. Louis, and I focus almost exclusively on estate and probate real estate. I help executors and personal representatives navigate the sale of property during what is often a very stressful and unfamiliar process. Missouri just passed Senate Bill 973, and part of what it does is bring a new layer of transparency to a type of real estate transaction that estates have been particularly exposed to. If you've been managing an estate, there's a good chance you've already heard from someone marketing themselves as a cash buyer, a we buy houses type investor, offering a fast, easy close. Sometimes those offers are from legitimate investors who will actually purchase the property. But sometimes, and this is what the new law addresses, the person making that offer is a wholesaler, someone who puts the property under contract and then shops that contract to other buyers for a fee without ever actually intending to close themselves. The problem isn't the practice itself. Some wholesalers provide real value. The problem is when an executor signs a contract without knowing that's what's happening, without knowing the price may be well below market, and without knowing the person they signed with may never actually show up at closing. As executor, you have a fiduciary duty to the estate and its beneficiaries. That means you need to understand what you're signing. Under Senate Bill 973, assuming it is signed into law by the governor and becomes law, the effective date is August 28th of 2026. Wholesalers dealing with residential property of 1 to 4 family units must provide sellers with a separate written disclosure at least 14 days before the contract is signed. That disclosure must clearly state 4 things. 1, that the buyer is acting as a wholesaler. 2, that the contract may be assigned to another buyer for profit. 3, that the wholesaler may never actually take title to the property. And 4, that the agreed upon price may be below market value. The statute also gives sellers the right to cancel the contract before closing if that disclosure was not properly provided. Violations can become claims under the Missouri Merchandising Practices Act. Here's the practical takeaway. If you receive an offer on an estate property and there's no written wholesale disclosure provided at least 14 days before you sign, that's a flag. It doesn't automatically mean that something is wrong, but it means you should pause and ask questions before you move forward. You should also know that accepting a below market offer without understanding what the property could realistically net and without documentation of your decision-making process can create exposure for you personally if a beneficiary later challenges the sale. The goal of this law is simply transparency. And as an executor, transparency is exactly what protects you. I've put together a longer video that goes deeper on SB 973 and what it means for real estate transactions in Missouri. You can access it on my YouTube channel at St. Louis Family Resources or my website, stlouisfamilyresources.com. If you're currently managing an estate and have questions about an offer you've received, or you just want to understand your options, I'm happy to talk you through it with no cost to you. I'm Terry Peterson with St. Louis Family Resources. You can reach me at 314-918-5151 or schedule a consultation at stlouisfamilyresources.com. Thanks for watching. Take care.